Hello and welcome to the Rogers Brief. I'm Adam Rogers. Thank you for watching and thank you for listening if you're catching this on Apple or Spotify podcast. I want to thank the new subscribers and viewers that we've gained this week. Just remind people that there is a little bit of a catalog being built up of different videos and blog pieces that you can refer to that have sort of setting up the hearings that are still scheduled to start at the end of this month. Just on that point, we haven't heard anything in the recent days or weeks about the schedule and if in fact the late January, early February start is still in place. Here in Nova Scotia, of course, we've been going through a surge or a new development in the pandemic with the introduction of the Omicron variant to Nova Scotia. Courts have been restricting in-person appearances. Our jury trials have been delayed a few weeks in January here, and the Desmond Inquiry was pushed back a couple of weeks as well. So we'll see whether that affects the start of the Mass Casualty Commission hearings. Haven't heard anything to that effect, so we'll just wait and see. Today I want to talk about another topic that is, I guess, an introductory to inquiries topic, and that is talking about the commissioners themselves. The three commissioners have been appointed for the Mass Casualty Commission hearings. We have former Chief Justice Michael MacDonald, Leanne Fitch, former Chief of Police in Fredericton, and Dr. Kim Stanton, a lawyer out of Toronto. I want to talk about how I expect they will run the proceedings. The first thing to note is that having three commissioners itself is unusual. If you've watched the video that I did or read the piece on inquiries in Nova Scotia and the history of inquiries, you'll know that most of the time there is one commissioner. The recent examples like the ongoing Desmond Inquiry, the Hyde Inquiry, the Nunn Commission, all had one. Now the Marshall Inquiry, the original inquiry in Nova Scotia, had three, but it is unusual to have more than one. The other thing I'd note is that none of the three commissioners are sitting judges, which is also very unusual. Now we do have, of course, former Chief Justice Michael MacDonald, and just a note of interest perhaps for some retired judges are allowed to practice again. They're allowed to practice as lawyers, and that's what Chief Justice MacDonald is doing. He's working for Stuart McKelvey as counsel there. They have a 3-year restriction on appearing in court, in the court in which they had previously presided as a judge or justice. So Chief Justice MacDonald, while not a judge, is still, of course, able to do this kind of work. So, but it is unusual to not have a sitting judge as in Desmond, Hyde, and Nunn. So first of all, the question is why three? Well, we look back at the history of this situation, and many familiar with it will know that it started off not as a public inquiry, but as simply a document review of, I guess, the police files, and that was the intention. And under those kind of circumstances, certainly you would say, well, yes, three people is better than one, three eyes, three different sets of expertise, different perspectives would add some weight to the findings, particularly if the three experts agreed on those findings. But is it still appropriate now that we have an inquiry? Well, to answer that question, we have to think about, well, what does a commissioner do during an inquiry? And there's really three roles. The first one is, and this is already happening, is that the commissioner organizes the research, the investigations, thinks ahead to the flow of the evidence and the witnesses. Certainly broadly speaking, they may not get down to the individual witness level or preparation of witness. That would be left to inquiry counsel, but the commissioners would certainly give an overview and some direction as to how that should take place. And that's a current and ongoing throughout the inquiry kind of a duty. The second one is to actually preside at the hearings. Now I expect that now this would be like a judge, or really in some ways it's like an MC at a wedding or an MC at an award ceremony. You've just got to keep things moving, make sure things start on time, the right person's at the microphone, welcome and thank and all that kind of stuff. So I would expect Chief Justice MacDonald would be taking the lead on that role. Experience at the Court of Appeal would help him in this because he has two other commissioners, just like having two other judges next to you, to say, okay, well, do you have any questions or do you have any comments, and inviting them to participate as well. So presiding judges, of course, have to deal with evidentiary issues, objections, that sort of thing during a trial. There's not really as many of those during an inquiry as there would be during a trial, where it's more of an investigation and not adversarial situation, but there may be some objections, and if it's something very minor, I would expect Chief Justice MacDonald to just handle it. If it's a more substantive comment or objection, then perhaps they would adjourn to have the three commissioners confer on it and come back with a decision jointly. The third thing that the commissioners do is actually write the report after the hearings are complete. That takes a long time. It takes months, usually, for inquiry commissioners to come out with their reports. I know there's a deadline in this case of November of 2022. We'll see if that is held or if there's some flexibility there. So when writing the report, the three commissioners may decide to divide the work based on subject matter, expertise. The other thing, though, you could have in this case is dissenting voices on certain topics where there's three commissioners. You may have, a lead opinion and then a dissenting opinion from one or more of the commissioners. So we'll see. And when we think about dividing the work into segments and expertise areas, we have Chief Justice MacDonald, who's been involved in cases from all kinds of subject areas. So I wouldn't expect much specialization there necessarily, but Commissioner Leanne Fitch, who's the former Fredericton Police Chief, she was there for 7 years. I would expect her to be more expert in things like police tactics, structure of the organization, that sort of thing. Also, she's done some work on intimate partner violence issues, and so may have some expertise there. Dr. Kim Stanton, who is a PhD doctor, is a Toronto lawyer. She was the head of the Women's Legal Education and Action Fund, which is a national organization, an advocacy organization. So certainly work in the fields of violence against women. That would be, I would expect, her expertise. So we'll see how that works when the report comes out. And perhaps as witnesses are being questioned as well, because that's part of the role of the commissioners. Now, just thinking about that, I mentioned earlier that none of these three commissioners are sitting trial judges, and the relevance of that is that trial judges are used to dealing with conflicting evidence and factual disputes and resolving those factual disputes, and it's a skill set that judges develop, and it's a comfort level that they develop over time, and so it'll remain to be seen whether these commissioners have that comfort level and if they're willing to jump in there. Now, in the Desmond Inquiry, for example, each witness testifies. The inquiry counsel usually goes first, and then other lawyers get to cross-examine. And then Judge Zimmer, numerous times at the end of that, has had his own questions for witnesses and has challenged witnesses on factual points or their conclusions as experts. So hopefully that we see that kind of activism from the commissioners here in the Mass Casualty Commission as well. The concern would be, to me, that they would tend to rely too heavily on the foundational documents, and I've talked about these before, but what those are, these are like agreed statement of facts. They're good for things like maps, for call log times, those sort of things that are not, not in dispute. They're not so good for disputed eyewitness testimony. Now think, for example, of the Onslow Fire Hall situation, which I talked about earlier this week in a video, and we have an official report from the Serious Incident Response Team. Many witnesses have disputed details from that. So to me, I think it's important that we hear from those officers rather than rely on the official CERT report to just be used as an agreed statement of facts. So I'm concerned about these foundational documents being overused and over-relied upon when there's actually disputes about the facts in certain situations. And the reason I'm concerned, or one of the reasons I'm concerned, is that I know that the lawyers for all the parties have been getting together for weeks now, I think up to 5 weeks, to create these foundational documents, which is a long time. And that's certainly more than just maps and call logs that they're talking about. So we'll see how that emerges and what the result of all of those discussions might be, hopefully before the hearings start later this month. And then we'll get to see the commissioners in action too, and see how the three of them interact. And hopefully it runs smoothly, operates as efficiently as possible while still getting to the bottom of these important details. So that's my piece, my commentary on the three commissioners and how that'll operate. I have more to say as the inquiry starts, as I observe how they preside over the proceedings, and so we'll see. So thank you for watching, thank you for listening to this today, and hope everybody is well, and we'll see you next time.